Hello and welcome to our Title IX training series. My name is Dean Shatley from the law firm of Campbell, Shatley in Asheville. I'm joined here with my colleague, Ashley Leonard. We appreciate you choosing us for your Title IX training needs. This is the first of 8 different sections in our training series. This one is going to cover Section 1, Title IX Fundamentals. And then we'll have, as you can see on the screen here, we'll have 7 other sections to cover different parts of the process, including we'll highlight the School Board Association's model policies and some potential changes to that. We'll highlight key personnel in the process, compliance issues. And then in Section 5, we will really start getting into how to respond to the allegations or to a formal complaint, investigations, and then hearings, and then lastly, determinations and appeals. For this point in time, let's go ahead and get started on Section 1, Title IX Fundamentals. This section is primarily for the Title IX coordinator and any other key personnel, such as investigators, which in K-12 is going to primarily be human resource officials or human resource department officials, as well as school-based administrators. So this section is for those folks. Also, it is for decision makers too. And then you can also use portions of this presentation for training of all school employees too. So let's get started. Here's just a little bit of an overview of the process that you will, I think, find beneficial to kind of, as we go through these sections, on how the process flows. So obviously we start first with the incident, and then if there is a report made, then we make an initial assessment. That's likely going to be by the Title IX coordinator, in conjunction with either the Human Resources Department or potentially even a school-based administrator, but an initial assessment of whether this actually rises to the level of a Title IX complaint or a Title IX incident. And then if it does, we'll move into the formal investigation, which an assigned investigator will investigate the incident and promulgate or publish a report of the incident, and then that will move to a hearing and final determination. Now, mind you, in K-12, you are not required to have a hearing in your policy. The North Carolina School Board Association model policy does include a hearing. We have recommended to many of our clients to remove the hearing provision and instead having a dedicated Title IX hearing. Just follow the normal due process of your discipline, student discipline hearings, or your employee hearings. And we'll get more into that as we go through the different sections. But then after the final determination, it can move on to an appeal as well. So let's start out with just a little bit of an overview. I think most of you watching know what Title IX is. It's federal law. Dates back to 1972, and it is a civil rights law, but it prohibits discrimination on the basis of sex in federally funded education programs and activities. So this includes K-12, it includes colleges as well. So any public or private school in America that receives some sort of federal financial assistance or aid must comply with Title IX. Obviously, this includes all public K-12 schools. And although we may not receive funding specifically for Title IX, we do receive other federal funding provisions such as Title I, as well as money for special education programs or exceptional children programs too. So Title IX is applicable to all of us. And lastly, the Department of Education, and more importantly, their Office of Civil Rights, is the entity responsible for not only monitoring, but ensuring that schools and universities remain in compliance with Title IX. As we start to talk about the new regulations, we will talk about more how this Office of Civil Rights, or OCR, in the Department of Education is the department that published the new rules and regulations that schools are going to have to follow from here on out. Let's talk a little bit about what is sex-based discrimination. This is not a term that's specifically defined within the law of Title IX and is not defined within the new rules of Title IX either. Rather, the department follows the Supreme Court's approach in interpreting the conduct and whether or not it's based on sex. This can include conduct of a sexual nature or conduct referenced or aimed at a particular sex as well. One thing to remember is that as we go through the new rules, which is really the reason for the training, is we're going to talk a lot about sexual harassment and sexual misconduct or sexual assault. But Title IX is much broader than that. Title IX applies not only to sexual assault and sexual harassment, it applies to general sex discrimination in all school programs and activities. For instance, probably the most commonly thought of program is athletics. So remember that many of the things that we're going to talk about will not have application to general sex discrimination. Rather, we're going to be specifically talking about sexual harassment and sexual misconduct in the school environment. But that doesn't mean that Title IX still doesn't apply, or Title IX's prohibition against sex discrimination in programs and activities doesn't still apply. So for the past 20 years or so, we have really, as school employees or counsel for school systems, we have underwent a lot of different guidance documents from the Department of Education and the Office of Civil Rights. And every time a new document is issued, we have had to sort of change the manner in which we approach Title IX complaints, especially as they relate to sexual harassment and sexual misconduct. Really beginning, and you see here a list of recent guidance dating all the way back to 2001, which was the first time that the Department of Education, I believe, issued guidance regarding sexual harassment by school employees or students or other third parties. But I really want to focus on the last 10 years or so. In April 2011, the Office of Civil Rights and Department of Education issued what's called a Dear Colleague letter regarding sexual violence. And although this letter focused primarily at the higher education level for colleges and universities, it still had applicability to K-12 schools. But once this was issued, a lot has happened since then. And primarily, part of this is the political movement too. And so every time a new president and a new administration comes into office, we're likely to see changes. And that's no difference here, or no different here. You'll see in September 2017 as well, we had a brand new question and answer guidance on campus sexual misconduct that was issued by the Trump administration. And basically this guidance was really sort of getting rid of the 2011-2014 guidance that came out under the Obama administration. But most importantly, and what's new, are the May 2020 regulations and final rule. So in the past, dating all the way back to 2001, there were not specific regulations and rules on sexual harassment or sexual misconduct in K-12 or higher ed colleges and universities. Rather, they were simply guidance documents interpreting the already existing rules. But these rules did not, the specific regulations that were already in existence weren't specific to sexual harassment. So instead, all we got were these guidance documents on how we should interpret the rules that were already in place. But in May 2020, the Department of Education finalized new regulations or a new rule specifically regarding sexual harassment. And then in September 2020, we saw additional guidance issued by the Department of Education discussing specifically how to interpret their new final rule that came out in May 2020. So in summary, this is really the first time since Title IX guidance has been issued in regards to sexual harassment that we have seen real final regulations on the topic. So here's just a brief history of the regulations. In 2018, in November 2018, Secretary Betsy DeVos announces the intention to restructure Title IX in regards to sexual harassment. And there was a public comment period going for approximately 18 months. That was actually November 29 to January 30, I think 2020. And then in May 6, 2020, the final Title IX rules were announced. And then in August, they became effective, and school districts across America were required to implement new policies and procedures, which I'm sure most of you have done thus far. Now, if your school district has not implemented new sexual discrimination and harassment policies under the new rules, it's time that you do so. You were supposed to have these in effect beginning in August 14, 2020. And so if you've not done so already, please contact your local council and let your superintendent know that it is very important that you get these new policies in place as soon as possible. Certainly the North Carolina School Boards Association has issued its model policy guidance as well. Those policies do bring you into compliance with the new Title IX regulations. And so if you do not subscribe to their model policy service, I would highly recommend that you reach out to your local council and begin the process of drafting and implementing a policy under the new rules and regulations. So what's covered under these new rules? Well, again, specifically, it's about sexual harassment. And not only sexual harassment, but it has to occur in an education program or activity located within the United States, of which we, the recipients, the school district, we have actual knowledge that it has occurred. And so let's break that down again. It's only about sexual harassment that's incurred in one of our programs or activities, again, located in the US, of which we have actual knowledge. And we're going to talk specifically about those words that are italicized and what they mean in an upcoming slide. So now if a person alleges misconduct that fits the above description, we, as a school district, we have a duty to respond. And the Title IX final rule sets out how we respond and how we respond appropriately, the due process rights that we give to the complainant, that we also give to the respondent, and the respondent is the alleged perpetrator here in this scenario, and the processes that follow, including the investigation, the potential for a hearing, and then a final determination, and then an appeal. And I want to reference one more time that these new rules are only about sexual harassment and misconduct. Title IX's application is much broader than just sexual harassment. Like we talked about earlier, it has a general sexual discrimination in programs and activities as well. But the new rules are just narrowly focused on sexual harassment. So let's talk a little bit about the key definitions here. So what is actual knowledge? What is sexual harassment? And then what is an education program or activity? Actual knowledge is notice of the allegations of sexual harassment by the Title IX coordinator or any other school employee. Now, remember, any other school employee, not just teachers, not just school administrators, not just school-based counselors, anyone that works for the school district, whether it's a custodian, whether it's a school nutrition worker, whether it's a teacher assistant, it doesn't matter. If they have knowledge, then the school district has knowledge of this allegation. And so if a student tells a school counselor, if a student tells the teacher assistant in their classroom or their teacher, and they fail to report it to the Title IX coordinator and the local school-based administrator, then we can potentially be held liable if we fail to adequately address the allegation of sexual harassment. So when you're doing your training for your school employees, the most fundamental and primary point that you have to drive home to them is that if you have any knowledge of any allegation of sexual harassment, sexual assault, rape, or otherwise sexual misconduct in the school environment, it is essential that you report it immediately, not only to your local school-based administrator or supervisor, but as well to the Title IX coordinator of the school district. Failure to do so, especially for employees, can potentially lead to disciplinary action for that employee. That's how important this is in this process. In higher ed, it's much different. In higher ed, it doesn't require knowledge by any college employee, just the Title IX coordinator or certain management or administrative employees. But K-12, while we're dealing with children, is much different. Now, one thing that you'll notice that's missing from the actual knowledge definition is knowledge by a student. Just because a student potentially knows of an allegation of sexual harassment does not contribute or attribute notice or actual knowledge to the school district as well. But once a student turns this information or gives notice to an employee, it is our duty to follow the process that we're going to talk about in this training series. So next definition, sexual harassment. Now this is really kind of a three-part definition, so I'm going to kind of go through it so slowly. The first is quid pro quo harassment. I think we all kind of understand that Latin term these days. It's used a lot in politics, but quid pro quo means this for that or something for something. So if somebody, if for instance a teacher says, I'll give you an A if you have sex with me, that would be quid pro quo. Or a supervisor tells an employee, if you go out on a date with me, or if you come back to my apartment, I will, and engage in some sort of sexual act with me, I will give you a raise, or I won't fire you, or something of that extent. Again, that's quid pro quo. Now, the second part of the definition is the key one that I think we will focus a lot on in this section, but also throughout the training series, and most likely will be the kinds of allegations that come to you as a Title IX coordinator or come to you as a district administrator. So the second part of the definition is unwelcome conduct that a reasonable person would find so severe, pervasive, and objectively offensive that it denies or effectively denies a person equal access to the school's education program or activity, including conduct based on sex stereotyping. Again, it's unwelcome conduct that is so severe, pervasive, and objectively offensive, it basically denies somebody's ability to participate at school. One key difference, and I don't want to go sparse these words too much, we probably will a little later, but one key difference between this definition and the definition of sexual harassment under Title VII of the Civil Rights Act is under Title VII, it's so severe, pervasive, or objectively offensive. Here, it's severe, pervasive, and objectively offensive as well. So it's a relatively high bar to meet this standard, and we believe that the new rules and regulations issued by the Department of Education really want just the most severe and egregious conduct to fall under this policy. But remember, another key component to this section of the definition is that it also denies the complainant's access or equal access to a program or activity in the school environment. And then lastly, the last part of this definition is any instance of sexual assault, dating violence, domestic violence, or stalking. And you're thinking, well, domestic violence is likely not going to play in here for students. But as we'll go into detail later, these new regulations also apply to employee on employee conduct too, or employee on student conduct. So there is the potential for some domestic violence as well as stalking. So again, three parts. One, quid pro quo. The second, unwelcome conduct that's severe, pervasive, and objectively offensive, that it denies somebody the ability to participate. And lastly, any instance of sexual assault, sexual violence, domestic violence, or stalking. So our last definition on this slide is education, program, or activity. Remember that the conduct must occur in an education program or activity. And so what this means is the conduct must occur at any location, event, or circumstances in which the school has exercised substantial control over, and the school in the context in which the alleged sexual harassment occurs. Now, this can include any building owned or controlled, even if it's by a student organization. So if a student organization rents out the school for the weekend to host some sort of event, that would apply as well. Going deeper into the definition here of sexual harassment. So let's talk a little bit about quid pro quo. Of course, this is conditioning the provision of an aid or benefit or service on the school of a person's participation in unwelcome sexual conduct. I provided you some samples on the slide earlier. Unwelcome conduct that a reasonable person would also find so severe, pervasive, and objectively offensive that it again denies a person their ability to participate in the school program or activity. And then again, lastly, sexual assault as defined in federal law, or dating violence, domestic violence, or stalking as well defined in federal law too. So here's a question for you. Ashley, let me ask you this question, and you can give us a little bit of an explanation. Does quid pro quo harassment need to be also severe, pervasive, and objectively offensive?
Nope. The Department of Education has determined that only the unwelcome conduct type of sexual harassment must be severe, pervasive, and objectively offensive. So quid pro quo does not need to be severe, pervasive, and objectively offensive. And that goes for the federal definitions of sexual assault, dating violence, domestic violence, and stalking as well. You can have one instance of sexual assault or a pattern of, two or more times of stalking, and that should be considered sexual harassment.
Very good. Thank you. So let's parse down a little bit into the scope of what an education program or activity is. Again, these are all locations, events, or circumstances over which the district exercises substantial control over, both not only the respondent, but also the context in which the harassment occurs. And so this can be a variety of things, right? This could, obviously, if it happens in the school, then we have substantial control over it. But it can also mean field trips, virtual learning, which is very big right now while we're in the pandemic. So if something is occurring over Zoom classes or GoToMeeting or Google classes, we have substantial control over not only the respondent, but the context in which the harassment occurs too. It can include anything that occurs on a school bus or at an athletic event or other event, such as like a band competition or choir competition or DECA competition as well. One of the things that it does not include is students at home texting each other. It wouldn't occur if one student sexually assaults another student in their apartment. They both live in the same apartment complex and it happens outside of school. But always remember that these events that might occur outside of the education program or activity still will likely have some sort of impact on these students, especially the complainant, in the school environment if the two students go to the same school. And so if you can establish a clear nexus between a sexual misconduct or sexual harassment that occurs outside of an education program or activity, if you can find a clear nexus to that activity or the harassment to the school environment, it still might not rise to the level of you being able to do something about it under your Title IX policy, but you may very well be able to do something, or the district can do something under your other policies and procedures, for instance, your student code of conduct. And so just be very clear on this. Just because something might not rise to the level of sexual harassment or it didn't occur in an education program or activity, you may still be able to address the conduct at some other level based on other policies and procedures that the district has ultimately implemented. And we'll get into some examples of that in a little bit. Some other definitions to go through too. So a report, we got to have actual knowledge. And so how do we normally get actual knowledge? It's most likely going to come through some sort of report by a student, the complainant, or even potentially another student or employee. So a report is a verbal or written notification that a person is an alleged perpetrator or victim of sexual harassment as defined by the regulations. And so it doesn't have to be in writing. A lot of districts have complaint procedures that require somebody to put the complaint in writing, but under Title IX, it can be an oral report or an oral notification or verbal notification too. It also doesn't have to come from the complainant in this sense either. It can come from a third party, meaning that it could come from the complainant's friend or coworker or teacher. And so we always have to be on the lookout for the report. And sometimes it will come to us in a manner that is not how we expect it to come. It might come over a third-party anonymous reporting system, something of that nature, but that still doesn't prevent us from assessing the report, and then potentially talking to the complainant to see if they want to file a formal complaint. And so, what is a formal complaint? Formal complaint is a document signed, so it has to be in writing, by the complainant or the Title IX coordinator alleging sexual harassment and requesting that school officials investigate the allegations. Ashley, this marks something a little interesting here. So a formal complaint can be filed by the complainant or the Title IX coordinator. I know we'll get into this a little bit further in one of the other sections, but give us an instance when the Title IX coordinator would file a complaint when the complainant refuses to do so.
Sure. So a complainant does not have to file a formal complaint. It's always up to a complainant whether to do so if the allegations arise to the level of a Title IX alleged violation. So if a complainant doesn't want to proceed with the formal complaint or refuses to, the Title IX coordinator can kind of step in the shoes to sign a formal complaint on behalf of the district. And those would typically happen in cases where the alleged misconduct is very pervasive. Let's say a respondent is alleged to have engaged in sexual harassment with multiple students or multiple employees. That's an instance where the school district would need to determine if they want to move forward without the complainant signing a formal complaint, because an investigation should occur to deter sexual harassment and remedy it to the extent possible. And just a note on reports and formal complaints, there are no statutes of limitation or deadlines for individuals to come forward and report sexual harassment or file a formal complaint on sexual harassment under the new regulations. You may receive a report of alleged sexual harassment that happened the previous school year. The Department of Education has taken the position that it doesn't matter, the school district still has an obligation to determine if that report or formal complaint arises to the level of a potential Title IX violation, and if it does, to go through the formal grievance process.
That brings up an interesting point I want to underline here about the statute of limitations. Typically, the Office of Civil Rights has a 180-day or roughly 6-month statute of limitations for a student to file a complaint in their office. But the interesting thing is, let's assume that the student makes a formal report to us, a formal complaint to us, that some sort of sexual harassment occurred more than 180 days ago. We still have an obligation to investigate it and go through the process. And then although this person might not have the ability to, or the complainant might not have the ability to file a formal complaint with the Office of Civil Rights, they do with us. And then if we fail to report it, we are thus violating Title IX, and then they could file a complaint against the school district for not going through with the process. And so keep that in mind. So 2 last definitions, I think pretty self-explanatory. The complainant, that's the person who is alleged to be the victim of the sexual harassment or misconduct. And then the respondent, that's the person who has been reported to be the perpetrator of the alleged sexual harassment or misconduct. So we got a hypothetical here. We got a couple different players, or 3 different players. We got teacher Doe, who is our teacher. We had Jane, 2, and then we got an anonymous student who is going to write something on the wall. So let me go through this, Ashley, and then I'll turn it over to you to maybe kind of give us some insight. So we have an anonymous student writes, "Teacher Doe likes female students on the mirror of the girls' bathroom in your middle school." Jane, a student, sees the message, takes a photo of it, and posts the picture on her private Facebook account. Sue, another student, sees the photo on Facebook and shows her mom, who is an elementary school teacher in the same district. Sue also says the bathroom message repeats a rumor going around the middle school that Teacher Doe has had inappropriate sexual relationships with multiple students. And that's what Sue tells her mom. So, does the district have actual knowledge of an alleged sexual harassment claim under Title IX? What do you think, Ashley?
I think so. So we want to take the definition, each definition, sexual harassment, actual knowledge, and then education program or activity. Remember, those are your 3 points that you need to hit for something to rise to the level of a Title IX violation under the new regulations. So, is it alleged sexual harassment? It might be. It looks like it could be, especially considering that Sue says the bathroom message repeats a rumor that the teacher has had inappropriate sexual relationships with multiple students. So that could be sexual harassment via sexual assault, depending on the facts as you would get into them further on down the road. Or it also could be a second type of sexual harassment, which is the unwelcome conduct that's so severe, pervasive, and objectively offensive that equates to sexual harassment. So it could be sexual harassment. Looks like it is based on the facts that we know. Does the district have actual knowledge? Remember, actual knowledge is any employee in the school district hearing about alleged sexual harassment. And the key here is that Sue's mom is an elementary school teacher in the district in which these students go to school. So even though the conduct is happening in a middle school, or alleged conduct is happening in a middle school, the fact that a school teacher in the same district has now heard of these rumors, yes, the district has actual knowledge of alleged sexual harassment. The third point that you need to hit is, did this happen in an education program or activity? Based on the facts that we have, we're not sure of yet, so we would want our Title IX coordinator to do some more fact gathering when reaching out to the students and determining whether this fact pattern actually hits each 3 points under Title IX.
Absolutely. And I think, on that last point, excuse me, on that last point about whether or not it occurred in an education program or activity, it may be very well likely that Teacher Doe, if he has actually had inappropriate sexual relationships with students, that occurred off campus. But, the Title IX coordinator could certainly assume that, or presume, I think, at least initially, that some sort of grooming had to take place on the school campus, in between classes, during class, what have you. And so something to always consider, that some acts may occur off campus, but some acts may also occur on campus too. So you can have both. So another hypothetical here. This time we have a male student who sends sexually explicit text messages to a female student using his personal cell phone and school-issued laptop. Both students are participating in remote learning due to the 2020 pandemic, and the social media exchanges occur during class time and outside of school hours. The female student initially responds, but then starts to feel uncomfortable and tells the male student to stop texting her. The female student reports the male student's conduct to her teacher 1 week later. The teacher remembers that 1 month ago, 2 other female students reported similar behavior about the male student, and he goes to the assistant principal, the teacher that is, goes to the assistant principal for advice on how to handle the matter. So first, Ashley, what should the assistant principal do? And second, does this situation occur in an education program or activity under Title IX?
So the assistant principal should immediately notify the Title IX coordinator of what's going on. Again, you as a regular employee of the school district, you do not need to determine, does this fall under Title IX? Your responsibility is, when you hear sexual misconduct, it triggers in your mind, oh, I need to tell the Title IX coordinator, because the Title IX coordinator is the position within the district who makes that determination. So when you hear potential sexual misconduct, you report to the Title IX coordinator. You've done your part under Title IX in helping the district to potentially respond to sexual harassment. Does this situation occur in an education program or activity? Yes. Even though both students are at home and sending text messages on their personal phones, they're doing it during class time, and that's what makes it occur in an education program or activity.
A couple important points here. Well, many important points. Thank you, Ashley. One is the assistant principal's got to tell the Title IX coordinator. Right now, normally, if something like this occurred, the assistant principal would likely tell his or her principal, and depending on how severe the conduct was, may also tell somebody in the central office as well. But you have to add another checkbox here, and that checkbox is to also inform the Title IX coordinator. And certainly, informing the Title IX coordinator doesn't mean you don't also inform your principal or the other appropriate personnel at the central office, but informing the Title IX coordinator is essential to the process. Remember, because the Title IX coordinator will be the one, and we'll get more to this later in key personnel, but that's the person who takes the does the initial assessment and talks with the complainant about the potential of filing a formal complaint that moves us through the flow chart of the process as well. So don't forget that you have to inform not only your other administration, but you have to inform the Title IX coordinator as well. So this brings up another good point about online conduct, but education program or activity encompasses all of a recipient's operations. And that can include their digital networks, their internet platforms, computer equipment, etc. If we control it, then that's going to be an educational activity or program. Sexually harassing conduct is not contingent on the method by which the conduct is perpetrated. And so two students texting each other on their own phones, not an education program or activity. Two students on a Zoom or GoToMeeting or Google Hangout with their teacher, and they are privately texting back and forth, or privately using the chat function in the video conference software. That is one of our programs or activities. And so it's a very subtle distinction sometimes, and why would one concern us and one wouldn't? But remember, we're specifically talking about what falls under the Title IX policies and procedures. Just because they're texting each other using their private phones, it might mean it's not an education program or activity, but it doesn't necessarily mean you can't address that conduct using some other policy or procedure, such as a code of conduct, student code of conduct as well. So keep that in mind. Another important factor is that, like all civil rights laws, Title IX prohibits retaliation. And so schools and districts cannot intimidate, threaten, coerce, or discriminate against an individual for the purpose of interfering with their Title IX rights, or because they filed a complaint, testified, participated, or refused to participate in a Title IX proceeding. Now, retaliation in how it relates to other civil rights laws like racial discrimination or sex discrimination in the workplace, retaliation has become one of the largest go-to areas for plaintiffs' attorneys, especially in employment law too. So remember this, it is so essential that when we have a Title IX process, when we're moving through the process, whether we're at the initial stage of assessment, meeting with the complainant, or we're at the investigation or the determination or appeal portion of the process, we cannot retaliate or allow retaliation. So we can't allow our employees to retaliate against the complainant. We can't allow them to retaliate against any witnesses or anybody who's refused to participate in a Title IX proceeding as well. And second, the exercise of First Amendment rights does not constitute retaliation either. Now, this was something specifically added to the new rules and regulations adopted by the Department of Education that was previously, I don't believe, in any other potential guidance ever issued by the department in the past. So I'm going to let Ashley give us some examples here of when a student exercising their First Amendment right would not constitute retaliation or potentially constitute retaliation as well. Ashley?
So adding the First Amendment piece to Title IX really makes things confusing for school districts. Keep in mind that there are two general rules that remain true and valid under the First Amendment. One is that student speech can be regulated if there is a material and substantial disruption to the school based on the speech. And the second rule is that student speech can be regulated if it constitutes lewd and vulgar speech that does not coincide with the school's educational basic mission. So with those two rules in mind, I want to give a couple of examples of how school districts will need to think about First Amendment speech rights along with Title IX. And because First Amendment cases are very fact intensive, you should always contact your local board attorney when one of these situations comes up, because it will change every time. So first example is from a case that occurred before Title IX was even enacted, and it was the Bethel School District v. Frazier case that was decided by the Supreme Court in 1968. So there was no consideration of Title IX at the time because it did not exist as a federal law, but now I think it's Title IX-ish because the facts in that case was Matthew Frazier, who was a student at Bethel, within Bethel School District, made a speech at a school assembly the assembly was dedicated to individuals running for Student Government Association. And his speech was in support of another male student that was running, but his speech was full of sexual innuendos and double entendres. He talked about how hard this guy would work for the student body, and it was very obvious what his speech was trying to do. So the school district suspends Matthew Frazier for 3 days for the lewd and vulgar speech that he made. He went through the grievance process outlined in board policies. His suspension was upheld, and so he sued the school district, saying that the district violated his First Amendment rights to free speech. The Supreme Court sided with the school district, saying that his speech was lewd and vulgar, and that type of speech is not protected under the First Amendment. So that goes to your general rule, which is you can regulate speech that is lewd and vulgar if it doesn't go to your basic educational mission. Second example is from 2011 in the Fourth Circuit, which covers North Carolina as a state. And it was Kowalski versus Berkeley County School District. And in this case, Kowalski was a female student. She was a senior who created a MySpace page. So it's a little dated because I don't think MySpace exists anymore. But it was similar to Facebook. And she created this MySpace page to sexually harass another female student that she went to school with. And the MySpace page title was, SASH, Students Against Sluts Herpes. That's didn't make a whole lot of sense, but it was aimed at harassing another female student. What was key was she invited 100 other students to join this MySpace page, although she created and posted on the page on her personal computer at her home. So it was all off-campus speech. The school district suspended her for 5 days for creating and posting to the page and inviting other students. She eventually sued the school district, saying that the school district could not regulate her speech because it was not on school grounds and not during school hours. But the Fourth Circuit ultimately sided with the school district, saying that her speech had a sufficient nexus to the school and that it was reasonably foreseeable that her speech would negatively impact the school. And because of that, her discipline was upheld. So again, general rules of if speech creates a substantial disruption, or if it's lewd and vulgar and not related to the school's educational mission, you can regulate student speech. And it's something to keep in mind when these Title IX cases come up, because sexual harassment and speech go hand in hand a lot. And so, again, when these do come up, please contact your legal attorney, because it is very fact intensive.
Thanks for those great examples, Ashley. Anytime you can work in MySpace into a presentation in 2020, you win the prize. So, but let me hit a couple points here, because this is anytime you overlay the First Amendment onto another federal right or federal civil rights law, such as Title IX here, it becomes even more complicated. Now, I will say, we believe that this provision of the new rules and regulations regarding the exercise of First Amendment rights does not constitute retaliation, is more geared toward higher ed, to colleges and universities, because certainly a college student has much broader free speech rights on a college campus than they do in a K-12 campus. For instance, college students can engage in lewd speech. You know, for instance, if in the Frazier case, if that speech had been given on a college campus, there would have been First Amendment rights for the student who did that, but not in K-12. And another aspect is hate speech. Hate speech is generally allowed to a certain degree until it excites some sort of violence or becomes actually threatening on a college campus. On a K-12 campus, not so much. So again, although this is geared towards, or this potential rule is geared towards higher ed more, it still will have application in K-12, and it becomes very complicated and nuanced. So as Ashley mentioned, definitely discuss this with your local council when a situation arises. The last point I really want to underline here on retaliation in general is that it's up to us to ensure, it's up to the district to ensure that retaliation doesn't occur. And that can be difficult because in the Title IX process, the key personnel, which we'll talk about in Section 3, the key personnel are all kind of siloed. And they're siloed because they each have their own part of the process to handle, and they don't want to have the Department of Education doesn't want multiple people engaging, or one person engaging in multiple steps in the process, because they would create some sort of bias or conflict of interest. But it's really up to us, the Title IX coordinator, and most likely the investigator as well, to inform folks that are engaging in the process, whether it's the complainant, the respondent, or witnesses, that they cannot retaliate against anyone else that's involved in the process, and they should not be subjected to retaliation in the process either. And so if they believe that they are being retaliated against by another school employee or another student because they filed a complaint or because they're providing some sort of evidence or facts during the investigation, that they should report that immediately to the Title IX coordinator so we can address it. Again, retaliation has become one of the largest growth areas in employment law, and we don't necessarily want that to happen in student-related issues too. And so if we're very clear up front with all those involved that retaliation will not be accepted and it is prohibited or it won't be tolerated, then I think we stand a much better chance of stamping it out from the very beginning. So during this process, we've talked a lot about misconduct that might not be or might not rise to the level of sexual harassment, or it may not have occurred in a program or activity in the school environment, but you might be able to address it some other way through your other policies and procedures. And so here are some examples of that. Bullying or cyberbullying, again, doesn't have to have a sex-based part to it, or even if it does, but it certainly doesn't rise to the level of sexual harassment or occurs outside, we still might be able to address it. So check your other policies. Hazing, whether that's occurring on an athletic team or some other program or activity, would be addressed in your other policies. Actual threats of assault or threats of physical harm, addressed in your other policies and procedures. And of course, discrimination and harassment in the workplace too. So all of these items might be addressed somewhere else and you have the ability, or the district has the ability to address these issues through its normal disciplinary process, whether that's a student discipline or employee discipline and termination. So keep that in mind. Just because something doesn't meet Title IX, the Title IX definition, doesn't mean we just stop right there and do nothing at all about it. So here's one last hypothetical. Shortly after enrolling at a new high school, a female student had a brief romance with another student. The couple then breaks up. And other students, or after they break up, other students began routinely calling the new student sexually charged names. They're spreading rumors about her sexual behavior and sending her threatening messages. One of the student's teachers and an athletic coach witnessed the name calling and identified it as hazing the new students sometimes experience. They also noticed the new students' anxiety and declining class participation. So there's a lot to unpack there, but think about all those things. Two students were dating and they broke up. After they broke up, one of the students was subjected to being called sexually charged names. Rumors were spread about her and her sexual behavior, and she was sent threatening text messages. Student's teacher and one athletic coach witnessed some of the name calling, but identified it as hazing. And so, how should the school attempt to resolve this situation? Ashley, what do you think?
I think there's a couple things the school can do. I think the student's teacher and the athletic coach who have witnessed the name calling and note that they've also noticed her anxiety and declining class participation, they should take that to the assistant principal or the principal to notify the next administrator in line of what's going on. If it doesn't click for them, hopefully it does. It should definitely click for the assistant principal or principal that, hey, this may be a Title IX situation, so I should report this to the Title IX coordinator. Again, regular employee, your job is to report it to the Title IX coordinator. So then your Title IX coordinator can determine whether the situation actually does fall under Title IX and the new regulations in terms of having actual knowledge of alleged sexual harassment in an education program or activity.
All right. Thank you, Ashley. And so let's just tie up a couple loose ends here before we finish up. And let's talk about what groups are covered under Title IX. It basically covers any sexual harassment, the new rules do, any sexual harassment occurring on a school campus or in a school program or activity, regardless of who those are involved. So it could mean student-on-student sexual harassment misconduct, employee-on-student, and employee-on-employee, which is something we have generally not addressed here. We've addressed it under Title VII in the past, but the Department of Education has made it very clear that employee-on-employee still falls under Title IX as well. It applies to applicants for admission or employment. It applies to student organizations and third parties participating in an education program or activity. And that can mean a school volunteer, or it could mean a third party who is providing some sort of manpower to the school districts. For instance, if your school district uses a third party contractor to provide your substitute teachers or to provide child nutrition employees or a child nutrition program as well. A school's obligation to respond appropriately to Title IX complaints is absolutely the same, irrespective of the sex of the parties involved as well. And so Title IX and Title VII protect all covered persons from discrimination based on sex, regardless of their sex, gender identity, or sexual orientation of the individual involved. Claims of discrimination based on gender identity are investigated by the Office of Civil Rights. Now, the Department of Education spent a lot of time talking about gender identity and sexual orientation inside of their commentary for the new rules, but these terms, gender identity and orientation, are not used in the rules themselves. Rather, what the Department of Education has said is that, look, if the harassment is based on sex in its broader term, then that is something that the rules apply to. So it doesn't matter if the persons are even of the same sex. Okay, and it certainly doesn't matter what the sexual orientation of either person is involved too. So, for instance, a respondent cannot can't use as a defense if the allegation is that a male respondent sexually harassed or engaged in sexual misconduct with a male complainant. The male respondent cannot use the defense, well, I'm not gay, I'm straight. So it doesn't matter if the persons are the same sex whatsoever or their orientation. How about students with disabilities? Do they need special considerations? Absolutely. Now, not all students with disabilities will need a special consideration, but for those that do, reasonable accommodations can be made. And the district should consider, especially the Title IX coordinator, should consider what kind of accommodations can the district make in the event of an informal resolution, I don't know why I said revolution, sorry about that, an informal resolution, or during the formal grievance process. For instance, does the student need an interpreter? Does the student need something put into Braille? Does the student need additional time to submit documents due to their disability? And so all of these items will come into play during the process if the student has a disability. And it could be that they have an IEP or a 504 plan, but it should always be considered, and any accommodations requested should certainly be considered by the Title IX coordinator. And if the coordinator needs assistance, it's best to see somebody like the EC director or the director of student services to figure out how best to accommodate the student's needs to get through the process. Well, I believe that is it for section 1. Thank you for joining us, and thank you, Ashley, for joining me on this one. We will be back with section 2, which will cover the North Carolina School Board Association model policies.